Hi everyone, good evening and a very warm welcome to Thorough Newspaper Analysis. This is the video for 8th of July, which is today, Monday. So let's start and let's first have a look at the agenda for the day. So first of all, in the editorial segment, we talk about an Indian Express article. The title of this article is How Did High Courts Interpret the New Criminal Laws for the Very First Time? Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So without further ado, let's start and let's first have a look at the heading of it again. So how did high courts interpret the new criminal laws for the very first time? Let's have a look at the context of it as to, why are we talking about the interpretation of these laws at such a soon, or in fact, I would say such a nascent stage, because we know that these laws, they've come into force from the 1st of July itself, which is just a week away. So let's have a look at the context of it first. So let's talk about the context of this case. Please understand, on 2nd of July, which is just a day later, that the three criminal laws, they came into force, the new criminal laws, the Delhi High Court and the Honorable High Court of Punjab, they had certain cases before them, two cases, one each, wherein these high courts interpreted that the Bharatiya Nagarik Suraksha Sanhita, which is the BNSS, which is the law corresponding to the CRPC, this law, it was interpreted for the very first time. Now, which is the section of this law that we'll deal with in just a bit. Now, the development, it came just a day after the BNSS and the two other criminal laws, which is the Bharatiya Nagarik Sanhita and the Bharatiya Sakshi Adhiniyam, they came into force. The judges in both high courts, they used section 531 of the BNSS. So please mark, section 531 is the relevant section here of the BNSS. And this is to decide whether to apply the old or the new criminal procedure laws on the ongoing cases, the cases which are pending. So there was a dilemma whether we apply the old or the new criminal laws to the cases which are pending. Now, this section, let's talk about the substance of it. So this section states that cases which are already underway, which are already pending, they should continue under the old criminal laws, under the old CRPC, as if the BNSS, it had not yet been enacted. So as particular section, the old law, the old CRPC has to be followed as if the BNSS has not come into force. And when is the situation arise? It is when a case is already underway. It is already pending. So now let's discuss the case before the Honorable High Court of Delhi. I'll just give you a crux of it in the beginning itself. So there was a dispute around trademark, and while that was going on, one of the parties to the suit, it furnished certain evidence, which was essentially newspaper copies showing that, this logo is ours and we've been advertising this logo. But then the other party, the defendant, counteracted this piece of evidence by saying that these newspaper copies, they itself are false, and they presented genuine newspaper copies. So here, since the plaintiff, it tried to furnish false evidence before the court, so therefore CRPC was invoked, a certain provision of the CRPC that we'll just have a look at. So here CRPC is invoked for the furnishing of wrong evidences, documents as evidence, So then the High Court was faced with a question as to whether the relevant provision in the CRPC with respect to the presentation of such documents be applied, or do we go to the BNSS? So this was the crux of Delhi High Court's case. Let's talk about this case now. See, KG Marketing India, it filed a trademark lawsuit at the Delhi High Court seeking an injunction against Rashi, Santosh Soni and Santosh Soni. So this was a trademark lawsuit wherein the relief of injunction was sought. Now, KG Marketing India, it was the plaintiff. It claimed that the defendants, they used a logo which was similar to their trademark, Surya Gold. And this logo essentially featured a sun caricature on a dark blue background. Now, in order to substantiate their claims, KG Marketing, it argued that they used to, make use of this logo or this label right from the year 2016 and presented newspaper ads from that year as evidence. Now, the Delhi High Court, as a result, seeing those newspaper ads, granted a temporary injunction wherein they prevented Rashi Santosh Soni and Santosh Soni from selling or advertising products using a logo which is similar to that of Surya Gold. So the Delhi High Court essentially, we can say, it was aligned in favor of KG Marketing India, relying upon the evidence which was presented by KG Marketing. Now, interestingly, in May 2023, the defendants claimed that the newspaper copies which were submitted by KG Marketing, the plaintiff, these were indeed false and fabricated. They then presented their own authentic copies as evidence. Now, naturally, the defendant filed a separate complaint alleging that the plaintiff, they knowingly used false evidence and made false statements. So, therefore, the defendants, they sought action under Section 340 of the CRPC. Now, this section deals with cases which involve documents presented as evidence. So now I hope we're clear how, in a trademark lawsuit, eventually CRPC was invoked, correct? Now here, Justice Pratibha M. Singh decided that to apply Section 531 of the BNSS, ruling that the proceedings against KG Marketing, they would continue under the old CRPC, under the old criminal law, which is CRPC. And she allowed the complaint against KG Marketing to be registered and, naturally, as a result, also dismissed their suit, imposing a cost of rupees 5 lakhs on them. Now, the second case is before Honorable High Court of Punjab and Haryana. Here, essentially, there was a person by the name of Mandeep Singh. He was convicted. So he was undergoing trial in a check bounce case, and eventually he was convicted and incarcerated. Now, this person, Mandeep Singh, he filed a revision petition in the Punjab and Haryana High Court under the CRPC. However, here we need to understand that he filed this petition 30 days after the time which is, given for such filing. So he was late in filing his revision petition. Now we know that whenever, there is a question of limitation, we have a separate law on that subject, which is the Limitation Act of 1963. There is a section in the Limitation Act, which is section number 5, which essentially provides for condonation of delay or pardoning of delay on certain grounds if you, put forth sufficient or good grounds or good cause for the delay. So here, this person, Mandeep Singh, he said that the delay of 38 days, it was a result of my imprisonment, as a result of which I could not apply for the revision within the time limit which is given under the law. Now here, Justice Anup Chitkara, he faced a dilemma whether the BNSS would apply to Mandeep Singh's case. The CRPC had been replaced by the BNSS that we all know by now, which applies to cases from 1st of July. Now, please understand, why are we bringing CRPCs? Because since Singh's revision petition, it technically began on 2nd of July when his delay was actually pardoned or it was condoned. It was unclear if the BNSS would govern this case because the application was filed before when CRPC was in effect. Now, to answer this question, Justice Chitkara, he referred to Section 6 of the General Clauses Act. Now, what does this section say? It deals with effect of repeal. Following a repeal, it states that any right, any privilege, obligation, or liability which is acquired, or any related investigation, legal proceeding, or remedy, it will be unaffected, and the repeal law will apply as if the repealing act or the regulation had not been passed. Now, therefore, Justice Chitkara, he also referred to a portion of Section 531 of the BNSS, which we've already seen. It states that pending appeals will be dealt with as if the new law, the Sanhita, it has not come into force. So after noting that the CRPC was in effect when both the petition, the review petition, and the revision petition and the delay application was filed. So therefore, he decided that it would continue to apply to Mandeep Singh's case. I hope it is clear, and now we proceed to the national news category for the day, where this is the first update. Indiabulls Housing Finance rebrands itself. Name, it is changed to Sammaan Capital. Indiabulls Housing Finance Limited, it has renamed itself as Sammaan Capital Limited, transitioning from a promoter-led lender to a board-run, diversified financial institution. It will shortly submit requisite applications with the exchanges for effecting change to name and trading in the shares of the company in its new name and new symbol. Next up is an update in the category of sports for the day. So 400-meter runner Deepanshi, she fails dope test and thereby is suspended by NADA, which is the parent agency so far as anti-doping it is concerned. NADA, it has suspended India's top female 400-meter runner Deepanshi after she failed a doping test at the recent national interstate championships where she had won a silver medal. This was the first positive doping case from the National Interstate Championship, which served as the last qualifying event for the Paris Olympics. Deepanshi does not train at the national camp. Next up is an update from Jharkhand, where the CM has taken oath. Hemant Soren takes oath as the Chief Minister for the third time. Jharkhand Mukti Morcha, which is the JMM leader, Hemant Soren, he was sworn in as Jharkhand Chief Minister for the third term. Hemant Soren, he first became the Chief Minister of the state in the year 2013 with support from Congress, RJD, and other political parties. He later won as MLA from Barhet in 2019. In 2014, JMM, it became the second largest political party, appointing Hemant Soren as the leader of opposition. Sopna Kallingal, she wins the Spice Award 2024. Sopna Kallingal, she of the Kallingal plantation, she receives the Spice Award 2024, which is instituted by the ICAR, Indian Institute of Spices Research. The award, it has been given to her for her initiative in enterprise diversification and integrated crop management strategies, thereby promoting a sustainable spice-based cropping pattern and system. Smart Cities mission, it is extended till March 2025. The Smart Cities mission, it is a novel expenditure. It is a novel, that is to say, it's a new experiment in India's urban development. Since June of 2015, the mission has introduced city competitions for about 100 smart cities, stakeholder-driven project selection, and special purpose vehicles for implementation, technology for urban governance, and third-party impact evaluations. Due to requests from state and city officials, the Government of India has extended the mission deadline to March 31st, 2025, which is next year, to finish the remaining 10% of the projects. This extension, it is aimed to ensure timely completion without extra costs beyond the allocated budget, benefiting urban residents' quality of life. Now, with this, we proceed to the international news category, with this being the first update here. SCO, the Shanghai Cooperation Organization, it concludes with the adoption of Astana Declaration. At the 24th edition or 24th summit of the SCO, leaders adopted the Astana Declaration and approved 25 strategic documents focusing on energy, security, trade, finance, and information security. Key resolutions included the cooperation programs to combat terrorism, separatism, and extremism for 2025-2027, the anti-drug strategy for the next 5 years, and its corresponding action programs. The summit, it also saw the adoption of an interaction plan amongst member states on the international information security issues. Following the summit's conclusion, China will lead the SCO next, and Qingdao, it will serve as the organization's tourism and cultural capital for 2024-2025. Russia approves 2033 completion plan for new orbital station. Russia has approved a schedule to create a new orbital station by 2033. This includes designing and building space modules, testing a new manned spaceship, developing launch vehicles and ground infrastructure, and establishing timelines for scientific institute contributions to the project. The scientific and energy modules will be launched first in 2027, and 3 other core modules, namely the Universal Nodal, Gateway, gateway and base modules, they will be launched by 2030. Two other target modules, they are scheduled to be launched by 2033. China leads global Gen AI patents. This is by as per the UN data. So China has become a world leader in creative AI technology by filing patents much faster than any other country across the world. Generative AI, it is a type of artificial intelligence that allow users to generate content such as text, images, music, audio, and videos. China launched a 3-year action plan in May to strengthen AI chip standards, develop generative AI, and enhance national computing power, aiming to advance in global tech race. Now, this has brought us to the legal update segment for the day. Women attaining motherhood through surrogacy entitled to maternity leave. So this is an important decision by Honorable High Court of Orissa. See, let's understand the Orissa High Court's verdict in a bit detail. So in a landmark decision, the Orissa High Court, it has held that a woman employee who attains motherhood through the procedure of surrogacy is also entitled to avail the benefit of maternity leave, as it is not only beneficial for the concerned woman, but also needed for a healthy rearing of the newborn. Let's talk about the background of this particular case. So the petitioner was working and she applied for the maternity leave for a certain period as she attained motherhood in 2018 through surrogacy. Now, after her maternity leave, she applied for additional leaves. She returned to work and the finance department requested a review of the leave application to ensure compliance with government service rules. The petitioner approached the High Court due to the absence of leave provisions for women employees who have children through assisted reproductive technology, which is also called, such as surrogacy. So let's talk about the court's observation here. Please understand, the court observed that under a rule, which is Rule 194 of the Odisha Service Code, women employees, they are entitled to a 180 days of maternity leave, including those who become mothers through adoption. However, there is no provision for maternity leave for women who attain motherhood through the ART, or so to say surrogacy, or the assisted reproductive technology methods. I would just like to give you the name of this case because this is important. Give me just a moment, please. Please note the name of this particular case is Supriya Jaina versus State of Odisha. You may make a note of it. All right, so the next update is from Honorable the Supreme Court. So high courts and trial courts have forgotten that bail is not to be withheld as a punishment. This is what the Supreme Court has observed, sending an important message to the courts across the country. The Supreme Court has recently lamented that the high courts and the trial courts, they've forgotten that bail cannot be denied as a punishment. The bench granted bail to a man under the Unlawful Activities Prevention Act, the UAPA, for allegedly smuggling counterfeit currency from Pakistan, citing his 4-year detention without trial commencement. They emphasized, the bench, that constitutional right to speedy trial, regardless of the security of the crime, it is important. The court highlighted that there is constitutional right to have access to speedy trial, regardless of the severity of the crime. The bench noted 3 striking things. First, that the appellant had been incarcerated for as an under trial. That is to say, while the trial is going on for 4 long years, while his co-accused have gotten bail. Secondly, charges have not been framed by the trial court. And thirdly, prosecution intends to examine 80 witnesses. So the trial, the charges have not yet been framed. Now, the court emphasized that under trials, including the appellant in this case, they are still accused and not convicted. So lower courts must uphold the principles of the principle of criminal jurisprudence that we follow, which is innocent until proven guilty. The court objected strongly to the delay in trial and extended detention of the accused. It ruled that that if the prosecuting agency and the court, they fail to uphold the accused's fundamental right to a speedy trial, then the state cannot oppose bail to by citing seriousness of the offense. The court expressed that Article 21 of the Indian Constitution applied irrespective of the nature of the crime, and it is not conditional on the gravity or the severity of the offense. You may make a note of the fact that right to, or the fundamental right to have access to speedy trial, it is considered under the ambit of Article 21 of the Indian Constitution. The appeal, it was allowed by the bench while observing the infringement of Article 21 by the manner in which the prosecuting agency and the courts have approached the present case. So why there is infringement? Because the person, he has been behind the bars for 4 years and charges have not been framed. The courts, they are not acting in a speedy manner, and thereby his right to have access to speedy trial is being compromised. The name of this particular case is Javed Ghulam Nabi Sheikh versus the state of Maharashtra and another. So this has brought us to an end of our DNA. Thank you so much for watching. Have a wonderful day.